Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. It's probably the right time to be talking about unimpressive cricketers. So, on the subject of unimpressive cricketers, let's turn to Chris Gayle. Chris Gayle was successful in defamation proceedings earlier this year. Those defamation proceedings related to the suggestion that he had exposed himself to a woman without her consent in the lead up to the 2015 Cricket World Cup. And let's just leave any comments about that sort of behaviour to the side, because we don't want to get ourselves involved in any defamation proceedings. Let's tick over to a recently made decision of the court arising from those defamation proceedings. So Chris Gayle wins. During the proceedings, he's made what's called an offer of compromise pursuant to the UCPR. And in short, that offer of compromise, so it's uncontroversial that offer of compromise entitles him to a costs order with those costs to be paid from the defendants, and the costs are reasonably significant. Now, during the proceedings, Chris Gayle has provided a guarantee as security for his legal costs. And what security for costs are, as you may know, they are the result of an application made by one party to litigation who says that there's some risk that the plaintiff in proceedings might not be able to pay any legal costs if they lose, because the plaintiff might be impecunious, low on money, and often it's a corporation in those sort of circumstances, or it might be an international person, someone who resides overseas. Chris Gayle resides overseas, to the best of my knowledge, and so a security for costs application was made, and he provided that security. So what he did was provide a guarantee of $350,000 to say, if I lose and there's a cost order against me, you can apply this $350,000 towards the cost order. And as I said before, as it turned out, Chris Gayle succeeded in his defamation proceedings, and so he said, right, might have that 350 grand back, thanks. That might sound all very reasonable. But what the defendants said was, hang on, we're thinking about appealing this, so it'd be really nice if we could hang on to that money and keep it in this jurisdiction, if we could make sure it is not repaid. Right. So these issues come before court, and the application is made to the judge, who firstly decided in Chris Gayle's favour, and the defendants say, the people who lost say, look, can we hang on to this security for costs amount? Can we keep this bank guarantee? Because we're going to appeal, and we might need to apply that money when we win the appeal. And so the judge is in a difficult position, because it's that judge who made the first instance decision, which is to say, if the appeal gets up, then it will be found that the first instance judge got it wrong. And so that judge is sort of sitting there saying, well, I don't think I got it wrong. And in any case, that judge wasn't taken to any law that would allow or that would lead him to make an order that the security would be held onto. And so that security was returned to Chris Gayle. No comment. The second thing that arose was the defendants asked for a stay on the enforcement of the judgment, to say, look, we're going to appeal, so can we have a stay? Can we hold off on the judgment amount, the amount we have to pay Chris Gayle? Can we get a bit of a pause on having to pay that? And without diving too deeply into the argument, essentially Chris Gayle agreed to a 28-day stay on half the judgment amount. So half the judgment amount straight to Chris Gayle. The other half, there'd be a bit of a stay just in case these appeal proceedings are going to be brought on. So, the fiddly one today. So let me recap. It was meant to be fun and jaunty and summary, and it actually got a bit complicated, didn't it? So what we had was Chris Gayle wins in defamation proceedings. During those proceedings, he put some security for costs down, a guarantee. He gets a cost order in his favour, remember, because he won the defamation proceedings. And the defendants say, whoa, let's keep this guarantee because we're going to appeal. And they say, well, we'll probably win the appeal, so we're going to need this guarantee. What the court says is, there's no reason not to return the guarantee, so that goes back. And as the arguments roll on about a stay of enforcement of the judgment, Chris Gayle, to his credit, well, you can form your view, agrees to half the judgment being paid to him promptly and the other half being the subject of a stay. So I hope that's slightly convoluted, but cricket and summer flavoured discussion of a recent security for costs judgment assists you. And I look forward to speaking again, grabbing another coffee and another case note soon. Cheers.